Hi, everybody. I'm Brittany Lewis with Forbes Breaking News. Joining me now is law professor and former General Counsel to the U.S. House of Representatives, Stan Brand. Stan, Colorado Supreme Court ruled earlier this week that former President Donald Trump will not appear on the state's 2024 primary ballot. And this is all under the 14th Amendment. So can you just start from the very beginning here and describe this 14th Amendment argument for us?
Yeah, very simply, it was passed after the Civil War to prevent former Confederates who had engaged in rebellion from occupying any federal or state office, any judicial office. So anyone who had previously in one of those positions sworn an oath to the United States and engaged in rebellion or insurrection would be disqualified from holding that office. With the caveat that Congress could, by 2/3 vote, lift those disabilities. And in fact, in 1872, and I think in 1898, the Congress did just that. They passed a bunch of amnesty bills because there were so many former Confederates seeking office and coming to Washington to plead for individual relief through private bills. And so they decided to deal with it on a general basis. There's been very little application of this provision in the post-Civil War era. It has come now to the fore because of the January 6th riot at the Capitol. And so there are a couple of cases that emerged. One involved Representative Cawthorn from North Carolina, who was at the rally and made certain statements, and voters in North Carolina attempted to kick him off the ballot. That case went to the Fourth Circuit, where the Fourth Circuit, the only thing the Fourth Circuit held was that the amnesty passed in 1872 was prospective, and so didn't apply to Cawthorn. That case became moot because he lost his primary. Marjorie Taylor Greene had a case in Georgia that was filed against her, and that case went up the chain in the administrative process. And an administrative law judge held essentially that what she had done on January 6th did not involve insurrection, that her statements were essentially puffery and blowing off steam, and she was not engaged in an insurrection through that activity. A county commissioner in New Mexico was actually barred from running for office. He actually had been arrested on January 6th, and a local court held that he was disqualified. And then, of course, we have the Colorado case, and we also have, I think, 12 or 13 other states where cases have been brought and haven't been finally decided. A portion of those cases were dismissed as either political questions or not ripe, and so those are in the pipeline. But this is the first one where the court, the highest court of the state, has ruled on the applicability of the amendment.
I just want to take a step back here, and we're talking about a former president. We're talking about the front runner in one of the two major parties. And as an American, as a lawyer, when you hear that they are disqualified from a state's primary ballot, what's your reaction?
Well, my reaction is there's a host of legal issues that are implicated by this case. Not the least of which, and all of which the Colorado court found in favor of the plaintiffs on. Is the president an officer of the United States within the terms of the 14th Amendment? People have argued, and the court held, that while the president and vice president are conspicuously absent from all the other host of people who are named, the implication of having an office under the United States includes the president and vice president. So that's one issue. The second issue, which is a very delicate one in the law, is this amendment self-executing, or does it require some action by Congress? Because one of the provisions of the 14th Amendment says, like the 13th, 14th, and other amendments do, say that Congress can implement this amendment by legislation. So there's been a fight over whether that requires some other action besides what a plaintiff would file in a state court. Beyond that, there's a question of what's an insurrection, because the amendment doesn't define it. Now, there's a criminal insurrection statute, but Trump wasn't charged with that. And so there's a factual dispute, and there was in the Colorado court, about whether he engaged in an insurrection. And then that's the last piece, is did he, through what he did, through the speech on the ellipse, through his tweets, through his other actions, did he engage in an insurrection? And that's essentially a free speech issue under Brandsburg v. Hayes, which says that you have to use fighting words. You have to use words that imply or intend to incite violence or riot. And so that's the other question. The court answered that in the affirmative. So there's a host of legal issues. And now this has all been thrown in a cauldron of other cases into the lap of the Supreme Court. And the confluence of other cases, I think, complicates this. There's already pending a petition by the special counsel to determine whether Trump's motion to dismiss, alleging that he's immune from suit, has to be decided quickly because there's a trial scheduled for March 4th. There's another case pending, which involves 18 U.S.C. 1512, which is the obstruction statute, under which the government has convicted 327 people. It's a 20-year felony, which is, in my view, why the government used it. And now the court has taken a case to determine whether the type of actions that these people were charged with is within the obstruction statute, which was essentially a post-Enron statute to prevent people from destroying evidence or obstructing the investigation through limiting evidence. And the argument is, well, that's not what happened here. And so the question before the court is what's the intent, what's the reach of that statute? So the court has three cases in front of it, one of which they've accepted, and they're all related in some sense because Trump has been charged with 1512. So any decision by the court to void the use of 1512 in any of these prosecutions would mean that one leg of their case against him would be knocked out.
I do now want to talk about the case you and I talked about a month ago, and that was Minnesota. And they threw out the case challenging Trump's candidacy last month. So A, why the different decisions here? And B, does the Colorado decision impact other states?
Well, it doesn't impact them in the sense that it binds or controls any other state. Each one of these states and their highest court are sovereigns, and they control their own, they interpret their own law. They don't have to follow. Minnesota kicked it out or ducked it by saying that basically the political parties control the primary process, and that until Trump becomes the nominee and has to be placed on the general election ballot, it really isn't ripe for decision, because the parties decide who goes on the ballot in the primary. Now this raises an interesting issue in Colorado, because what I've heard, and I haven't seen this reported, but I've heard that one of the things the Republicans are considering doing in Colorado is changing their rules to provide that the nominee be selected by a caucus instead of a primary, which would mean that they could remove his name from the ballot and select him through the caucus, and it would be free to do so under this decision, because he wouldn't be on a primary ballot, and the Secretary of State wouldn't have to resolve these issues.
So you're saying a caucus basically would be a workaround here for Trump?
Yes, at least in Colorado.
The majority opinion noted, we've noted that this is really uncharted territory. So how tricky does that make this?
Extremely tricky, because there's no controlling precedent to look at, or there's no even analogous precedent to look at. The cases that I reeled off in the beginning, none of those reached the merits. In 1922, the House of Representatives refused to seat a guy named Victor Berger, who was a socialist candidate from Milwaukee, because he had opposed the U.S.'s entry into the war, World War I, and was against the draft. And they claimed that that was, in effect, giving aid and comfort to the enemy under the 14th Amendment. I think that's a ludicrous precedent to rely on, since he wasn't, he was actually charged with the Espionage Act and convicted, and his case was reversed by the Supreme Court. He subsequently re-ran and was seated. So we don't have any experience with this. And, as a result, what the lawyers would term this is that the court is writing on a clean slate. And here they've been thrust into the political vortex because the obvious political implications of this. So they're going to be struggling mightily with how to deal with these issues. Now, there are some off-ramps for them. I think they could punt this case and decide they're not going to decide it right away, maybe even until he becomes the nominee. That's another issue here is, when does this get decided? Does it get decided at the point when he tries to put his name on the ballot? Does it come when he's elected, if he is? And who decides that? So we're all searching for answers, and while this court has supplied the answers for some of them, the Supreme Court hasn't been heard on any of this.
Let's talk about the Supreme Court. Obviously, everyone has been saying this is going to be kicked up to the Supreme Court. So A, what do you think the likelihood of that happening is? And B, what's the likely outcome here?
Yeah, again, I don't think you can predict what the outcome will be. It's not a science. The Supreme Court has what we call certiorari jurisdiction, which is defined in their rules and in the statutes, but it's discretionary. It's the ultimate decider. They could decide whether they have jurisdiction. They could decide whether it's ripe. They could decide whether they want to decide all the case or part of the case or send it back. They have really unfettered discretion on how to handle this. And since we don't have any clear precedents, it's really a guessing game about, what will happen next.
Do you think Trump has a good argument then?
I think he has a number of arguments. There's another problem here, which is uniformity among the states. Now, while the presidential election, contrary to popular belief, is not a national election, it's 50 state elections, and each one of these states, pursuant to the constitutional delegation to the states to decide the time, place, and manner of elections, subject to certain qualifications elsewhere in the Constitution, you need some uniformity. Think about a case where he's taken off the ballot in one state, but not in another, or where several states take him off the ballot, with the effect that the Electoral College count on November, 2024, is skewed because certain states aren't being counted. So it's really it's a potboiler of legal issues that we don't have answers to.
Your point about uniformity is really an interesting one. So let's pretend here, hypothetically speaking, that the Colorado ruling is upheld and Trump is off the ballot. Will this cause an avalanche effect in other states?
It could. Were the Supreme Court to reach the ultimate merits and say, yes, this qualifies as a grounds for kicking him off the ballot under the 14th Amendment, I think that would be binding on every state.
You and I had a conversation yesterday and Bush v. Gore came up and you were comparing this to that. Can you talk a little bit about that for us?
Yeah, I mean, not to be flip about it, but Bush v. Gore was, nursery school compared to this. That was a very narrow case involving one state and whether the recount in that state was constitutional or violated the Equal Protection Clause. The candidates were separated by a mere 500 votes. And it was decided on a very narrow ground and resolved the dispute for that time. Now, since then, the polarization and disputation over elections has increased geometrically, as we witnessed in 2020. I mean, we had 60 cases in court. We had certification issues in some states, although those were largely, overcome. Every single state, including states controlled by Republican secretaries of state and Republican legislatures, certified the vote. But the disputatious nature of our election infrastructure has been magnified, tenfold since 2000.
This is obviously historic. It's obviously monumental. What type of precedent do you think this is setting now for future presidential elections in this country?
Well, it's like I tell my students, Watergate, which I believe is the precipitating event for all of this, it's like the fall from grace in Genesis. Once Adam and Eve got kicked out of the garden, nothing was ever the same. And since Watergate, in Washington, legal politics, nothing has been the same. And so every time we cross one of these thresholds of new controversy and new legal issues, we tend never to go back. We simply magnify those. We had an independent counsel statute where we had scores of independent counsels under numerous presidents. And so, we've created this system of legal procedures and processes impacting our electoral system. And I don't see how that ever goes back to the way it was. It never gets simpler.
From what you're describing, it sounds like we've been on this slippery slope really for 50 years or so. You're the expert. What do you think is next here?
Well, we're in it right now. And I think, before 2024 is out, we'll know more. We'll know what the viability of the 14th Amendment is. We'll know whether former presidents can be indicted and tried. We'll know answers to a lot of these questions. Maybe not finally, because to the extent that any of these cases go to trial and there's a conviction, there will be appeals from that, and that will take years. I mean, that's one of the problems here. Everyone expects the legal system to deliver a quick and simple resolution, and that's not the system. Once you're in the judicial law, you're in for all types of twists and turns, As David French, who's a conservative writer, wrote in the New York Times, he said, you can't think of these legal disputes as who won and who lost. It's trench warfare. Who advanced on that day and who retreated on that day. And ultimately, it takes years to resolve these issues, sometimes without any clear enunciation of a simple, rule. So we could be in this for a while.
So to go off of your trench warfare analogy here, who do you think is advancing slightly now?
Well, you'd have to say, looking at the full spectrum of what occurred since January 6th, the government has been advancing with occasional setbacks, and the former president has not prevailed in a definitive way in any of these cases, but that we're not at the final juncture yet. So, he lost the Vance case in the Supreme Court, fighting over his business records from, the district attorney in Manhattan. He won, in my view, the case against the Congress for those same records. At least the courts trimmed back the subpoenas. He lost the case against the National Archives for his records to the January 6th committee. But along the way, there have been victories. While it's not his case, he could benefit from the 1512 examination by the Supreme Court because he's been charged. If that went away because the court ruled that statute didn't apply, that'd be a major advance for him.
We aren't at the final juncture yet, as you noted, but you did such a great job in November breaking down Minnesota's ruling for us. You did a great job now breaking down Colorado's ruling. And I'm curious, because once again, you are the expert, what do you think is missing from this national conversation?
Well, I think it's hard for the public to follow all of this because it's so fact and law intense and in so many different forums. There are these cases in the state courts. There's the prosecution in Washington. There's the prosecution in Florida. There's the state case in Georgia. And so we're really in a legal landscape that is, for lay people, very hard to follow. Even for a lot of lawyers, it's hard to follow. Lawyers that don't practice in any of these areas. And I think that's putting tremendous stress on the legal system and tremendous expectations on judges and on the judicial system, some of which they may not be up to. Because remember, I think it was Madison who said, the courts, the Supreme Court is the least dangerous branch. Why? They don't have an army and navy. They can't appropriate money. They have their robes, and what they have is public acceptance of what they do. So when you look at this case and you think about that, while they're not supposed to make political decisions, they have to be sensitive to the limits of their own authority and the public's willingness to accept what they do. That was the problem with Bush v. Gore. It was a 5-4 decision that sowed incredible discontent with the court, quote, looking political. Well, that risk is magnified by multiples in this case. So something else operating on the court internally, I think, will be a bit of trepidation about how far and how fast they should go with any of this.
Regardless of the way the court rules, do you think there's any way that it won't look political?
No, to a certain segment of the population, increasing our polarization, just as with the Dobbs decision, just as with some of the other decisions. One side will say they're political, the other side will say they're following the rule of law. And so they have become embroiled, not necessarily through their own fault, but they become embroiled in the political debate. And so I don't know how they escape that. I think it'll depend a little bit on how they handle these cases.
Once again, I really appreciate you joining me, breaking this down, navigating what you described even as a very tough legal moment. So, Stan Brand, thank you for joining me.
My pleasure.